Okay, fine. Welcome to today's class. So here is your Pushpashri ma'am, and I will be going on today with our CA foundation in that the first chapter. So in the first unit, that is your Indian Contract Act. The first chapter is your Indian Contract Act. So with this chapter, today we'll move on. Before going on to this chapter, so you might have studied the law before, or you might have not studied the law. So today I'll tell you in detail what is the law, what are things are going to be study in this chapter. So totally in our law, we have a five units. In that 5 units, we have a sub chapters. In that, the first unit is our Indian Contract Act 1872. So, Contract Act, what do you mean by act? So, this is the thing that you have to know. So, coming on to an act, what is the meaning of an act? Act is nothing but it's the rules and regulation. So, made by the government. So, how do they are going to make? Let me give you one example. Imagine there is a problem that there is no traffic signal. Okay, the problem is there is no traffic signal. When there is no traffic signal, when there is no cops, when there is no traffic police and all, can you imagine how the Bangalore will be? What's going to happen in the Bangalore? Obviously, the number of accidents will be increasing. There will be an increase in the number of accidents, and a lot of people may lose their lives too. So, what is the ultimate solution for this? What is the solution we can have it for this problem? The solution we can have for this problem is to make some rules and regulation. So, you can ask, ma'am, how do we can make a rules and regulation? So, we can make a rules and regulation here. Who are all going to make a rules and regulation? So, government will appoint a few people. Okay. So, they are going to write one book regarding this rules and regulation. So once they frame this book will go for the houses of the parliament. It goes for the parliament. In the parliament, this book will be reaching two houses of the parliament. One is your Rajya Sabha and the another one is your Lok Sabha. So when Rajya Sabha and Lok Sabha, when they are going to accept this book, they're going to pass this book. Once the book has been passed, it will become an act. Okay, so that is how, as of now, we are having Motor Vehicle Act. According to this act, you people will get a license. According to this act, if you wanted to pay the fine, you go with this act only and you're gonna pay the fine. So everything is related to this act only. So this is what we are gonna call it as an act. So coming on to this chapter, the Indian Contract Act of 1872. So what was the major problem they faced? The problem was the corruption they faced. A lot of people were making use of the money rather than the other ways. They was not making sure that they were not maintaining the proper books of accounts, and they were not keeping the records, whatever they are going to have, the receipts or the payments and all. So for that, the solution was they wanted to have a contract. Contract is nothing but where the two people are going to agree. So as soon as they agree, so they're gonna make some contract. So once they make some contract, what they're gonna do, they'll be sharing the profit and losses equally according to that contract agreement. So in the same way here, they made the book regarding that contract rules and regulation. This book went to the parliament, both houses of the parliament, Rajya Sabha and Lok Sabha. In both the houses of the parliament, once the book was been passed, later onwards, it became the act. So that is what we're gonna call that as a Indian Contract Act of 1872. So suppose here, if you wanted to make any kind of contract now also, you go according to the act and you're going to make the contract. So now we'll just go with your first chapter. I just gave you an introduction about it. So then what are the things that we are going to learn in this chapter? I'll just give you a chapter overview. So in this chapter, the first thing we learn about the elements of the contract. That means if you're making a contract, what are the things to be included? Suppose if you're making a contract, we tell that there must be at least two parties, you have to make some agreement, and whatever agreement you're gonna make, the law has to accept that, the people has to accept that. So all these things we tell it. So these are all the elements. So these elements contained in the section 10 of Indian Contract Act, and few are not contained in the section 10 of your Indian Contract Act. Even that also we're gonna study. And then we study about the essential elements of a valid contract. Suppose if your contract has to be a valid one, suppose if the law has to accept your contract. So when the law has to accept your contract, you should be having some valid things in the contract. So what are those valid things should be there in the contract? About that also you see it here. And then you see the different types of the contract. We have a valid, we have a void, we have a voidable, we have a voidable contract, agreement, illegal, all those things we're going to study. And coming on to an elements of contract, we have a two elements. One is thing is when you're gonna make an agreement. The another thing is an enforceability at the law. So enforceability is nothing but an acceptability of the law. How we are going to accept the law? See, kids, these are all the law terms where you have to use it when you're writing the answer. Since it is a descriptive paper, make sure you will be using these words like enforceability or assent. It's nothing but acceptance, all these things. Okay. So these things about these terminologies I'll be telling you in between the chapters. And in agreement, we have a two things. One is the offer and one is the acceptance. Suppose here Mr. A is transferring his goods to Mr. B worth rupees 100. Here A is transferring the goods to B, right? So A is called as an offerer, B is accepting the goods. So I'm going to call him as an acceptor. Okay. So in the same way, here we have some rules regarding offer. We have a different types of the offer. We have the essential things included in the offer. And then if you're accepting it, any offer, what are the communication you're going to make regarding that offer? Even that also you're going to study here. So apart from that, you see some of the legal rules of a valid acceptance. So if you are accepting any kind of the contract, what are the legal rules that you're going to follow? Along with that, you do have a communication of acceptance, like however you have a communication of offer, you do have a communication of acceptance. Even that also you're going to study in this chapter. So going on to further with this chapter, we'll go with the law of contract. So law of contract, these are all the things you can just blindly study this one time, not so much important. Just go through this one. So overall, I have said you till now, same thing is that and that part. And that coming on to a contract, what do you mean by the contract? It has been defined in the section 2, subsection H of your Indian Contract Act 1872. What does it's gonna tell you? So it tells that an agreement enforceable by the law. Any of the agreement that you people are going to do, if that agreement has been acceptable by the law, if the law is accepting that agreement, then only we're going to call that as a contract. If a law is not accepting that contract, then it will not be called as a contract. If law is accepting the contract, we have a word for that contract is called as valid contract. If a law is not accepting this while accepting, if a law is not accepting, we call that as a void contract. Okay. And here, whatever the contract that you people are going to make, we have the two things involved in that contract. The very first thing is an agreement, and the second thing is an acceptability of the law. So then you can ask me, what is an agreement? Agreement is nothing but, according to our section 2, subsection E. You can remember this section, how you can ask me. See, agreement, E comes, right? So section 2, subsection E is an agreement. You have a tricks to remember. So know this tricks, okay? So agreement, the term agreement is being given in this section. So here, what is an agreement? So here we can see an definition. Every promise and every set of promises forming the consideration for each other. Say for example, here A is telling B that he'll be delivering his goods worth rupees 10k or 10,000. So here A is making a promise to B that he will give the goods. And then In regard, B is promising to A that he'll give 10,000 to the A. Okay. Every promise and every set of promises forming a part of consideration to each other. Here, when A is giving the goods to B, the consideration for the B is the goods. And in return, B is giving 10,000 to the A. For A, the consideration is 10,000. Okay. Every promise, every set of promise is going to form a part of consideration to each other. Here, nobody is getting the loss, nobody is getting the profit. They are giving money for that, the valuable consideration they are getting. Okay. So this is what an agreement means. So in the agreements, you can observe we got one word called promise. So then, what is the meaning of promise? So promise has been defined under section 2, subsection B of our Indian Contract Act of 1872. According to that, promise is nothing but when the person to whom the proposal is made signifies is nothing but tells, signifies his assent. Assent is nothing but acceptance. Okay, signifies is assent. There to the proposal is said to be accepted. Proposal when accepted becomes a promise. So then here you got one word called proposal. Proposal is nothing but offer. Offer can also be called as a proposal. The same example I take, when the person to whom the proposal is made, here A is making a proposal to B. Okay, so that means he's selling his goods and services. So A is going to give an offer to the B, and B is going to tell that he will be accepting the goods. When B tells that he'll be accepting the goods, then it will become a promise. So here A will tell to B that he'll deliver for the goods for such so this much of consideration, and when B is going to accept that goods for this much of consideration, then we're going to call that as the promise. So now in a short, when the person to whom the proposal is made signifies as assent that the proposal is said to be accepted, the proposal when accepted becomes the promise. Okay, so these whatever we studied in about definition, we have it on the points. Okay, for your easy way of studying, you can read every point one time. Okay, and you have to know this is an important thing where agreement is equal to offer plus acceptance. If you want to make an agreement, suppose here if A and B wanted to make an agreement, here A should also be there and B should also be there. Why A should be there? Because to give an offer. Why B has to be there? To accept the offer from the A. When offerer or the proposal or the acceptor, when these two people are there, then only the agreement can be made. So if not, the agreement cannot be made. Okay, so this is what we're gonna learn it in this contract. So moving further, so then we have the eligibility by the law, enforceability by the law. So as I have already said, enforceability is nothing but acceptability. So why law has to accept? Because you're making a contract with a law only, right? So according to the law, it has to be accepted. If the law is accepting your agreement, then only it will become a contract. If a law is not accepting your agreement, then it is not going to become a contract. If a contract has to be made, there should be an agreement and there also should be an acceptability by the law. Okay, so that is what we're gonna learn it over here. So here is some example. I'll just explain you one of an example which is there here. So what they're telling here, A is going to sell his car to the B. So for at rupees 2 lakh rupees. Okay. But A is having some obligation, something that if he's going to give the car to the B, what they have to do it? B has to make the 2 lakh of payment to the A. Okay, because A is giving his car. So if B is not giving the car, if B is not refusing to make the payment, if B is refusing to make the payment, then we are not going to accept that. So if A is giving the car in return, if B is making the payment, it will become the contract. And here A is having every right to receive the 2 lakh, and B is having every right to receive the car because he's giving the money, because he's receiving the money. Okay, so that is according to the law. So that is what they're giving you an example here. So your further examples, you can just study it for the further part. And then we have a difference. This differences are important on your examination point of view. You can just go with your definition. You can just go with your differences so that it will be easy. Coming on to a meaning of agreement, what you mean by an agreement? Agreement is nothing but every promises that you are going to make, every set of promises. Agreement defined under section 2 subsection E, contract defined under section 2 subsection H. If you don't remember, it's fine. You just go with that, okay? So whatever the promises that you are going to make, every promise and every set of promises forming a part of consideration to each other is what we call it as an agreement. And coming on to a contract, any agreement that is being enforceable by the law, we're going to call that as a contract. And then we have a scope for agreement. Here we'll be having a legality and we'll be having a social agreement too. But in the contract, we will be having a narrow sense. It's nothing but only legality we're going to see, but not the social agreement we can see here. And then coming on to a legal obligation, agreement will not have any kind of legal obligation, but contract will have some legal obligation. And this is the very important thing you have to know. All agreements are not contracts, okay? But all contracts you make, that is going to make an agreement. The best example I can give you is a marriage agreement you can make. Okay, you can make a marriage agreement. We can't call that as a contract. It is just an agreement. Okay, because it is included with a social agreement. But here I can't call that as a contract. Okay, so that is what all contracts are the agreements. So this thing you just go through this once. Whatever we said, just those things are. And then we have a next concept called essential elements of a valid contract. What are the essential elements? If a contract has to be a valid, if a contract valid is nothing but if your contract is enforceable by the law, if your contract has been acceptable by the law, then we're going to call that as a valid contract. So for that valid contract, what are the essential things are there? So these are the things given under section 10. These are the things which is not given under section 10, but even though we consider these things as essential elements. So coming on to agreement comes under section 2 subsection E, that tells like every promise and every set of promises forming a part of consideration to each other. Suppose if both are making an agreement, then we can call that as a contract. So then it comes under our Indian Contract Act and it is an essential element. And then free consent. Suppose, I'll give you an example for that. A and B. A is selling his car to B for rupees 2 lakh. Here, A has to sell his car to B with his wish only. For A, some C is forcing to sell his car, so A is selling his car. Then it is not called as a free consent. If A wishfully is going to sell his car to B, then we call that as a free consent. So here, nobody should force you to enter into the contract. You has to agree with all your opinion of positivity. You have to enter into a contract. You can freely enter into a contract. That is what a free consent. Okay. And then competency of the parties. If there is a two-party called A and B in the contract, both has to perform in the contract. Until and unless if both are not performing in the contract, we're going to make all that as a contract. If A is performing in the contract and B is not performing, if A is selling the car, B is not making the payment, then we are not going to call that as a competency. If A is selling the car and in the car B is making the payment, then we call that as a competency of the party. Both has to participate in the contract. Okay. And then lawful consideration. Suppose if A is selling a breezer car to the B and that is of I can take like 2020-22 okay 2020 model. The cost may around 10 lakh when A has bought that car. It won't be 10 lakh. I just take an imaginary figure. When he's selling it for B, B cannot ask that car for 50k because it is not worth of 50k. For 50k, will you get a car? You won't get the iPhone only. How can you get the car? You get the iPhone, but not up to a good range, right? So here, when A is selling the car of 10 lakh to B, he may sell around 7.5 or finally he may go, first he may tell like 9.5 or 8.5, then he can come up to 7.5. So that is regarding a lawful consideration. Suppose if A is selling the car to B and B cannot tell to A that I'll go and get the star from the sky, is it possible? It is not possible. It's very impossible. We're never gonna call that as a lawful consideration. Whatever consideration you're gonna give it for the person, consideration is nothing but something in return to your promise. Whatever the consideration you have, you are going to give it for the person. It should be acceptable by the law. And then legal object. Suppose if you are going to, suppose A will tell to B that he is going to get the star from the sky and he is going to give it for B. In regard, B has to give 1 crore rupees. Is it possible? Do you have any legality of that object? Can you see that object anywhere? The star coming onto the hand and then selling? No, obviously you cannot do that. It's all imaginary things, right? So only when you have a legal object, then you have to consider that as a contract. And then not expressly declared to be void. So these things further you will be studying under these sections. So this I'll go in detail further. But in short, if you want me to tell, not expressly declared to be void. Suppose I cannot perform the contract. Here you are giving your card to me and you are asking 5 lakh. So I will tell first, okay. But what happens later on few days, I won't be having 5 lakh. So I buy your car and I tell that I'll give the amount in a future days. But in future days, I refuses to make the payment to you. So then I can't tell that you just after using your car for 2 days, I can't tell you to take your car and go. Right? That is not the right way. So that is not expressly declared to be void. I should not tell myself that I don't want to enter into this contract after entering and all. About this further we will study that. Okay. And then few things not given under section 10, but even though we consider, what are all those things? Two parties, obviously there must be an offerer and there must be an acceptor to accept that offer. If the seller is there must be obviously buyer should be there to buy the product, whatever the seller is going to sell. If there is no two parties, the contract will never takes place. And then intention to create legal relationship. I can't give you 10K and go and tell you to kill some minister. Is that possible? Do you think that is a legal relationship? Obviously, it's not a legal relationship. Suppose if I'm giving you 10K and if I'm telling you to do some social work, obviously it's a legal relationship, right? So whatever contract you're going to make, that should be of legal things and that should be acceptable by the law. And then fulfillment of legal formalities. Suppose what are the legal formalities comes here? Suppose if you're making a contract with, if A is making a contract with B, if they are going on with some partnership business, they must have a partnership deed. What do you mean by deed? Deed is nothing but an agreement. The another word for the agreement is the deed. Okay, so fulfillment of legal formalities. A has to fulfill the legal formalities of B, then only he can enter into the contract. So that is only when you fulfill the formalities according to the law, then only you can enter into the contract. Certainty of meaning. The same thing as I said you. Once I gave the car, you cannot tell that I'll be giving the star from the sky. Is that possible? Obviously, it is not possible. So that's not the certainty of meaning of whatever the work that you are going to do it. And then possibility of performance. Whatever the things you can perform, you have to tell that. So suppose today I'm giving my car to you. So you can't tell that I'll go to sky and I'll come from the sky and later I'm going to give you the amount. Is that possible? Going to the sky, coming back again. I don't know whether you will come back after going to the sky or not, right? So that is possibility of performance. So if you're possible to do a performance of the contract, then only you can make a contract. Unless and until if you couldn't be able to make the promises, whatever is there in the contract, we cannot make payment to you people. So that is your possibility of performance. So these are the important things that your people have to know in this chapter. That means the essential elements in this contract. I hope you people have understood this. So now I'll just go with a further. And here you have one line according to the section 10. All agreements are, I said you already this line. So these line, just go with that important one. I have already said you that. So again, I won't touch the same thing. So whatever I said you, same are here. We'll just go with this one time. And here we will be having a certain case studies, and that's important. So here we have a two parties. So what these two parties will tell you, that means if you are making the contract, at least there must be a seller or the buyer. That means there should be an offerer and the one must be an acceptor to accept that contract. So regarding this, we have one case study, that is Gujarat versus Ramnath. So what happened on this? It's actually a partnership. Okay. So when there was a dissolution, when there was a wind up of this partnership, what happened? They had some assets. They bought it to a business and they started to divide that assets among them. That means Gujarat started to the state of Gujarat and Ramnath. So this is started to divide it among themselves. And on that time, if they are dividing with themselves, there is no need to pay the taxes. If they wanted to sell it for the other person, then they have to pay the taxes. Okay. So on that time, sales tax officer, what happened? He wanted to tax the transaction, but that contract was being held just because since they are the partners, they are sharing between them only. But if they have been given those assets to another third party, if they would have sold to a third party, then they would have been paid the tax. So since they are not giving it for the third party, no need of paying the tax over here, just because they were a joint owner of the business, whatever they have been started. And then the parties should have an intent to create a legal relationship. Here we have one case study called Balfour versus Balfour case study. What happened in this case study? This was a case study between an husband and the wife. Husband was there in the abroad, wife was there in the India. Okay, I'm just telling you randomly. So husband, so after going on to the abroad, he just before going on to the abroad, he just said that he wife that he'll be giving a certain amount to you just for the survival. He just said like that for the wife, and he went to the abroad. For the first 2 or 3 months, he gave the amount, but later onwards, he refused to make the payment to the wife. So 2 3 months, wife saw no amount came from the husband. She went to the court. She filed a case. She sued the husband. She surrendered the husband. So what happened on that time? So on that time, the law or the court refused this kind of cases just because they considered this was a domestic agreement, that was a legal relationship between the husband and wife. They should not make any kind of such contract. So if they're making any kind of this agreement, that will be coming under a social agreement. So here the parties is not having the right to create that social agreement, and the court rejected that agreement. Okay. So the next thing, we have other formalities in the certain cases. So say for example, if you are making any kind of insurance contract and all, you might have seen that it's usually accepted in the written format itself. And also you can see some kind of signs and all. So that's the other formality. Certainty of meaning. It is nothing but, suppose if I'm going to tell you that I'll be giving a 10 tons of oil, I have to mention in the contract what kind of oil I'm giving to you, whether I'm giving the sunflower oil, whether I'm giving a coconut oil, what kind of oil I'm giving you. So there must be a certainty of meaning for whatever the thing, whatever the contract that I'm going to do it. And that possibility of performance of an agreement, possibility of performance of an agreement will tell you, if you can perform, you have to make a contract. If you can't perform, you cannot make that contract. Okay. And we have essential elements, whatever we studied now, all things are here. You can just go through this one. Okay. So same thing, lawful consideration not expressly declared to be void. Same thing, whatever we studied, the same things are there. Let's go through that one. This is about your first part. And then we have a second next concept, that is types of the contract. Okay. So this thing we'll just discuss in the next class. So this, I think, is enough for our today's session.